Good morning. My name is Ron Fox, and welcome to the Fox Smith Legal Symposium, free to our clients every year. I want to welcome you to the seminar, and I want to thank you for attending. At Fox Smith, we understand that every matter that is sent to us is important to our client, and we treat it as such. When we get a new matter in, we work very hard to make sure that we immediately contact our clients and talk to them about what it is their goals are. We work collaboratively with our clients in an effort to make sure that they obtain an effective and efficient result promptly. We also take it as a real honor when clients send us work. And today's seminar is our effort to say thank you for the trust that you have placed in us when you send us new matters. Today, you're going to hear from a number of my partners. All of them are experts in the fields on which they're going to be speaking. We sent you an email earlier which provided you with the biographical information for each of those partners, and you can see from looking at those that they each have a great deal of experience and knowledge about the areas that they're going to be talking about. We also provided you with a listing of the different areas of law in which we practice. That should help you understand the kinds of service that we can provide. Today we're going to talk about three topics. One is employment law, especially in the era of this pandemic. The second is risk management and litigation avoidance. And the third is what happens when you're involved in a lawsuit. What are the first things you should do when you're sued? What are things that should be done as you proceed to defend yourself? And how do we evaluate cases? Before we begin, there's just a few preliminary matters I want to describe for you. First of all, I want to say thank you to Alaris Litigation Services. Because we could not do this live and had to do it virtually, we had to rely upon a top-notch videography company to provide that service to us. And Alaris Litigation Services has graciously agreed to provide that service to us free of charge. Second, I want you to know that we sent you an email just a few days ago in which we provided you with the PowerPoint presentations that you'll be seeing on the screen today. So you have those available to you for future reference. Also, these seminars are very important to us and they're important to our clients. And we make a real effort to try to communicate effectively on topics that clients are interested in. And so we would ask that at the end of this seminar, you respond to an email that we're going to send to you. In that email, you will see an evaluation form, which gives you an opportunity to rate our performance. It also gives you a chance to tell us topics that you would like for us to speak about in future seminars. Also, please know that because of the limited time that we have during the 2 hours that we're going to do this seminar, and because of the virtual nature of the seminar, we really can't take questions as we make our presentations. But if you have questions, please write those down on the evaluation form and send them back with the return email that you send to us. As our way of saying thanks for giving us the evaluations, we'll send you papers that cover some of the topics that we're going to discuss today. We are grateful that you are attending the seminar with us today, and I want to say thank you, and I hope you find it helpful and informative.
Today I'm going to discuss some discovery considerations to protect your positions both prior to and during litigation. So there are three overarching ways to lose a case, and only one is truly in your control, and that's discovery handling. Ignoring discovery handling can result in settling a defensible case because relevant information was destroyed and the court has issued sanctions for spoliation, or you overpay at mediation to avoid disclosure and related collateral discovery issues. Many times over the years, we have been called in to assist or take over litigation because of improper discovery handling. On those occasions, we have been successful in repositioning the client to as favorable position as possible. But in each of those cases, the defense was significantly jeopardized and it was entirely avoidable. Further, on some occasions, it was clear the information that was lost included information which would have been helpful to the defense. Also, please keep in mind that discovery violations can impact other pending litigation by creating a specter of spoliation, resulting in unnecessary scrutiny applied to your discovery efforts in other cases or across your entire docket. This translates to increased costs. Now, I've identified a number of discovery violations or noncompliance. Most common one is failing to produce responsive materials, and the most egregious is failing to preserve responsive materials. We're going to focus on the latter, spoliation, and how to avoid it. Given our limited time today, we're going to briefly highlight spoliation under federal, Illinois, and Missouri law just as a framework for this discussion. So under federal law, you'll turn to Federal Rule Civil Procedure 37 to find the context and framework for spoliation. But in general, there must be a finding that the party acted with the intent to deprive another party of the information's use in the litigation, and the party was in fact prejudiced by the act. This is far less of a hurdle than you might suspect at first. Intent to deprive under federal case law is obviously intentional deletion, but less obvious is failure to take reasonable steps, for example, failing to issue a litigation hold. Also, delay resulting in unavailability has been found to be intent as well as prejudice. The example there is you fail to institute proper preservation activities. An employee, perhaps disgruntled, deletes the information on the way out the door, and now you're left to deal with that because the information was available and now it is no longer available. And obviously, prejudice, in addition to that example, is inferred where the information lost was not favorable. Where that'll come into play is as a witness will testify to the type of information, along the lines of, well, I was repeatedly instructed to do this, but of course those emails are now gone. And so that'll be used to infer the intent. Missouri, just briefly, Missouri is very similar to federal rule, except in Missouri, the spoliation doctrine arises under case law. And here, intent again is required. Generally, the courts in Missouri are looking for evidence of fraud, deceit, or bad faith. Illinois is a particularly challenging jurisdiction and takes a very different approach to spoliation. Illinois has pattern jury instructions for simple failure to produce information, as well as a separate cause of action for spoliation, and that cause is styled negligent spoliation of evidence. The key elements are the existence of a duty to preserve, the duty was breached, and the breach proximately caused an injury or damages. So under Illinois law, mere negligence is sufficient. That is, put another way, a showing of intent is not required. So what are the typical remedies available? I've listed them here on the slide for you in order of likelihood, at least based on my research and experience. The driver here is severity of the actions or inactions. Most common, what we see are monetary awards and adverse inference. Monetary award would be fees and costs for pieces of the litigation, or the other side's fees incurred in identifying and addressing the spoliation. Adverse inference, this typically arises where the information was lost and it's determined was likely unfavorable. And as an example, a district court has allowed as an adverse inference that destroyed documents may, and this is a quote, evidence a corporate culture embracing attempts to remove mention of or an attempt to conceal or to underplay expressed safety concerns. So in this particular case, with that inference, the defendant was was left to concede causation and essentially left to argue damages. As you can see, spoliation can be very devastating to your case. So how do we avoid that? We do that with preservation. And the duty to preserve, quite simply, is you have an obligation to preserve evidence that's under your custody and control. This arises from common law and various procedural rules, and it's measured by reasonableness. Courts consider not just whether the party in fact reasonably foresaw litigation, but whether a reasonable party in the same factual circumstances would have reasonably foreseen litigation. So here, consider your triggering events. This is going to be a fact-specific inquiry, but examples would include an incident resulting in significant physical injury or property damage. Someone threatens to sue you. You've denied an insurance claim, or a company takes actions that could result in litigation. For example, terminating an employee or terminating a contract. So the first step, and courts generally view this as a necessary first step to facilitate preservation, is issuance of a litigation hold. A litigation hold letter or email, uh, it needs to have these umbrella categories that I've set out in the slide for you. The letter should be issued in every instance, regardless of the amount at issue, following triggering of the duty to preserve. The instructions should clearly inform recipients what information is covered and instruct them not to delete or destroy it. Follow up is the step most often missed. Make sure that the hold was received, understood, and followed. You should also inform the recipients compliance with the hold is mandatory, and if for some reason it's not feasible, then they need to immediately notify the designated contact so this can be addressed. Additional considerations, you may need to refine the litigation hold as the case develops. Early on, the information is limited, but as the case develops, you're going to have discovery requests. You'll have parties added or dismissed. You may have claims added or dismissed. All of those things will affect the scope of the hold. Issue the hold as privileged and maintain it with related communications and documents accordingly. And what kind of documents we're talking about here? You need to document your efforts to preserve who, what, when, where, and why. Also, make sure you're including what information was not preserved and why it was not. For example, you may have had hard drive failures on your server. That's completely out of your control, but 3 years from now, you may very well forget why that information is not there or the incident won't have been documented. So this will let you get in front of arguments on spoliation. Also, assume the litigation hold and documentation are discoverable and drafted accordingly. Just a quick note, some will point to proportionality language as an ability to limit your hold. This is a double-edged sword. Consider, for example, that you're making a deliberate determination to exclude information from preservation. If that information is subsequently lost and the court disagrees with your proportionality analysis, then the conduct may likely support a spoliation motion. Just a word on scoping the lit hold, and it cannot be too narrow, nor should it be too broad. So in order to develop an appropriate strategy, you need an understanding of what information is likely relevant, who the relevant custodians are, and what information they have access to, and where that information is located. Also, don't forget about new or replaced systems. Offsite systems or physical storage are also sometimes overlooked. And this is just to get you started. The process will evolve as you work through it. And this leads us to some special considerations in light of COVID-19. So with COVID-19, our rush to telework, though understandable, has brought with it many unintended consequences, some that may impact discovery and preservation. I want to highlight a few of those for you. Consider each offsite employee is potentially a data repository. Information may be saved locally to their computers rather than to the designated systems on your network, since it is more difficult to access network resources remotely. Accordingly, preservation of local devices is increasingly important. When employees are on network, these devices may be duplicative of other sources, but that may not be the case any longer. Also, your usual preference may be in-place preservation, and that option may be appropriate in ordinary course, but that is not where we are at the moment. Ask if preservation in place is appropriate for your current configuration. For example, will it be found to be reasonable practice if your custodians are working remotely and their systems are no longer on network and so are no longer subject to routine backups? Now consider whether they are using their personal computers to access your network. Some companies did this for convenience of the employee or due to limited resources. But the question is, do you have their consent to access those systems if needed to meet your obligations? After all, those are their equipment and you do not own it, so they have a right of privacy in that equipment. So what backups are they running is another question. Also consider, do they have appropriate antivirus and security software to access your network safely? Most of these issues can be easily addressed through relatively simple policies and procedures, but the evaluation and the actions need to be taken to avoid the spoliation concerns we've been discussing. Finally, I want to mention just briefly some common missteps, putting aside the COVID issues. Failure or delayed investigation and issuance of a litigation hold letter is what we most often see, followed by network changes. And here I'm talking about hardware changes. Desk workstations, laptops, phones are replaced and changed out over time, and proper preservation activities are not engaged. and so information may be lost. Don't trust the copy to the new system unless it's been verified. They're not always duplicative. So, as a final note, all of this work is not just for the benefit of the opposing party. Unfortunately, on more than one occasion, I've had to engage forensic experts so we could locate and recover potentially exculpatory evidence that was thought lost because investigations were not conducted until suit was filed, which is often months or even years after the underlying event. So with that, I'll turn the presentation over to Larry Pratt for discussion of venue-related concerns.
Thank you, Ryan. And thank you all for being here with us this afternoon. I'd like to talk to you about a couple of things. We've had some development. First of all, we're going to be talking about venue and jurisdiction and what kind of spin COVID-19 is putting on some fairly traditional notions of what's going on in these various places. I'd like to talk to you about developments in certain venues, and then we'll talk about what unique spin COVID's put on them. Now, I think most people would agree that the consideration of venue and jurisdiction is one of the most important issues in evaluating a claim and planning a litigation strategy. So that's why they're so important. Here, we're going to primarily be talking about the main jurisdictions in which Fox Smith practices, Missouri and Illinois, two very different jurisdictions that have within them some very different venues. Now, specifically, all of us as trial attorneys are aware of some common perceptions about local venues within Illinois and within Missouri. For instance, the city of St. Louis, and which is a county in and of itself. It is not part of St. Louis County, and Jackson County, where Kansas City is located, are traditionally considered both the bench and the jury pool as being very pro-plaintiff. Conversely, St. Louis County itself is considered to be more pro-defendant. And then, of course, we have the area that we refer to here in St. Louis as the Metro East, dominated by Madison and St. Clair County, Illinois. And then we have to consider, of course, Cook County, where Chicago is. They are very pro-plaintiff, both the bench and the jury pool, so much so that the American Tort Reform Foundation has labeled them judicial hellholes. So, we've seen some interesting developments, though, things that are kind of shaking up our conventional approach to some of these different venues. For instance, the city of St. Louis used to have a large blue-collar workforce. Those jobs have moved away or have ceased to exist. So our former garment district is now the loft district. The people who are living there tend to be retired people from the county. So, and we have seen increases in Washington University and St. Louis University and their medical campuses, which is, we believe, resulting in more folks that tend to have a little bit more conservative outlook. Conversely, the counties where most of the people live in the metro area, and so we're drawing from a very large jury base and from the entire geographical area. And sometimes it's hard to predict who's going to show up in your jury pool. North County is predominantly lower income. West County is going to be wealthier, middle income. And South County is going to be middle income to blue collar. You never really know who you're going to get. Now, the same can be said to a certain degree with Madison and St. Clair. They've sort of kind of become bedroom communities of St. Louis. So we're seeing the juries in some of these areas get a little bit more conservative. But of course, things being the way they are and the culture being the way it is, the benches still have more of a pro-plaintiff bent. One interesting thing we've seen is the 5th District Illinois Court of Appeals, which covers Southern Illinois, has traditionally been very pro-plaintiff and an insulator for the trial judges in Madison and St. Clair County. But now we're drawing more judges on this Court of Appeals from the more conservative rural areas of Southern Illinois. And one of our partners, Mike Donaldson, got a forum nonconvenience motion granted, amazingly. It was taken up to the 5th District and it was sustained. 10 years ago, we might not have even filed a motion like that, let alone thought it would be granted. Very interesting developments in the 5th District. If you're interested, give Mike a call or contact him on email through our website. Now, all of this is all very well and good, but what kind of spin is COVID putting on this? Well, one of the ways we determine what we think about a venue is who we expect to show up for jury duty. Now, let's take the city of St. Louis, for instance. The city has traditionally the lowest percentage of people showing up for jury duty. The city also tends to be lower income. Now, with regard to the county, so the question then becomes, who does that leave? If you already have a smaller pool of people, and then we throw in COVID, elderly people can typically be relied upon to show up, but now they are in a high-risk class. How is that going to affect our jury pool? And we know from statistics that African Americans and Hispanics, both as a population, have been disproportionately impacted by COVID. How is this skewing now, which maybe we can expect to see, going to affect who shows up for jury duty, who our potential pool is, and more importantly, how that affects our preemptory challenges at trial. The Batson decision governs who you can and cannot remove on preemptory challenges, and it's based on things like race and other protected classes. If the pool is skewed, how is that going to affect how we can exercise our preemptory challenges? Things we have to think about. What kind of another issue? We've talked about the elderly. They can usually be relied on to show up, but now they're a high-risk population. How is the court going to deal with that? And you have parents with school-age children. Now, that's always an issue in voir dire, but now you have no schools. So everybody's child is at home. How is the court going to address these very real issues? That leads you to the issue of, if you have fewer people showing up and you're going to have more health-related and family need issues, how big does your voir dire panel need to be? Typically in the city of St. Louis, they're large. But if you're going to have so many more people raising health and family issues, how big is this voir dire panel going to have to be when you already are going to have smaller pools? And then where do you put them, keeping in place appropriate social distancing? Different jurisdictions have tried to tackle this. St. Charles County, which is a jurisdiction north of St. Louis, has used their family event center. It's a stadium, and they have conducted voir dire there using social distancing. And then once the jury is picked, they have retired back to the courthouse. We have yet to see how that really kind of plays out, but we've got some other guidance from some other jurisdictions. The Federal District Court in Maryland tried a case, and they went through a long explanation of how they rearranged the courtrooms and installed barriers, took out fixtures, reconfigured the HVAC system for fresh air, and then brought the jurors in small groups. Well, first of all, who's going to pay for that? Now, that is a relevant question when you consider jurisdictions like Madison and St. Clair County, Illinois, who think it's okay to charge a defendant a fee just to be able to file their answer to a case, and a separate fee to get a jury. Are we looking at maybe a revision of court costs to cover some of these COVID-related issues? Who's going to bear that burden? Is it going to be the criminal dockets? Probably not. It's likely to be the civil. So, from a practical standpoint, can you get your case tried? Well, there's a huge backlog. We're going to have some time to figure out these issues, because when we do start trying cases, it's going to be the criminal cases, because the Sixth Amendment speedy trial right demands that. Practically, we're going to have family law cases next, and civil cases are going to be dead last. What does all this mean? What do we do? It can have impacts. There may be some benefits here. The biggest hammers plaintiffs have are the threat of trial. If there's no trial date pending, we may have some opportunities for advantageous settlements. Conversely, we also know that old claims really start playing the devil with our clients' budgets, loss runs, and reserves. So these issues are going to have to be answered on a case-by-case basis. But what are we going to do? Well, we're going to do what we've always done. We're going to take into consideration the particulars of each venue. We're going to watch what the court does. We're going to participate as much as we can in the decision-making as to how these cases are going to be tried and handled. And we're going to preserve the issues that need preserving. And we're going to get these cases done and get them moved. One thing to consider, as Bart mentioned, alternative dispute resolution. It's got its pros and cons, but the one good thing is the parties control it. Thank you for being here, folks. And I'd like to introduce Tom, who will have our next issue subject.
Thank you, Larry. So far, we've talked quite a bit earlier today about steps you can take to avoid a lawsuit. And you may remember Maggie and Richard talked first about some steps that can be used to help avoid getting sued, including, of course, following applicable federal and state statutes, having appropriate and complying with company policies, procedures, and guidelines. Bart and Ted talked earlier about utilizing release agreements or arbitration agreements in order to avoid having a lawsuit. Ryan talked about preserving evidence as another way of either preserving the evidence, but another way to avoid a lawsuit or at least be prepared in the event of a lawsuit. One of the things Richard mentioned earlier is that employees, persons, parties can sue for anything. And I would agree with that, but unfortunately, I will probably take it a step further and say that people do in fact sue for anything and everything at times. I tell my clients often, and I hate saying this, but it does come up, in the climate that we all live in and work in today, it's not if, it's when. You are going to have a lawsuit. If you have a business or engage in virtually any activities in this day and age, you're going to have a lawsuit. So one of the things many of you may have seen and received at times is a settlement demand or a claim demand. And it shocks me, and maybe it shouldn't at this point after this many years, but I still get surprised by how many times the plaintiffs make a demand for $1 million or they demand policy limits, and they may not even know what the amount of the policy is, but yet they want the limits. We see that all the time. Well, fortunately, not every case is worth $1 million, and not every case is worth the policy limits. I want to talk briefly about some of the factors that go into influencing a case value. There's generally 3 prongs to most any case. There's a liability prong, a causation prong, and a damages prong. The liability prong first is, what did the defendant do wrong? You look at the conduct or the behavior by the defendant. Was the action taken discriminatory in the employment context? Was there malpractice, or did the defendant deviate from the standard of care in the medical setting? In just a simple automobile setting, did the defendant run a red light, or was he speeding? Products case, was the product defective? Some of the evidence that we look to in making these determinations and what would be presented to the jury at trial would consist, of course, of party testimony, deposition testimony, fact witnesses, medical records, the personnel file, police report, company policies and procedures, industry guidelines. But what is so important is early investigation and, as Ryan mentioned, preservation of these documents, and of course, to the extent you can, testimony about the incident in question. It's imperative that this is done at an early stage in order to save all of this important information that may impact and influence a jury making a liability assessment. Second prong, as I mentioned in most every case, is causation. Did the defendant's conduct cause the injury? Some factors that we can look to, of course, in a physical personal injury setting. Was there a pre-existing injury? The claimant or plaintiff is claiming a back injury, but we find medical records that the plaintiff had a pre-existing back problem. Same situation that he's now claiming and seeking recovery for in this lawsuit. We also look at whether the injury would have occurred anyway. For example, in an employment situation, a claimant might allege that they are terminated due to a discriminatory action on behalf of the employer. However, we have seen situations where we might develop testimony and evidence that the claimant may have lied or misrepresented things on his or her employment application that would have made that person ineligible for being hired. You can use that as a defense to show that there was no causal connection between the alleged discriminatory conduct and the action taken or the damages sustained by the plaintiff. In a medical setting, we might look at a patient may claim that they died from an untimely diagnosis of cancer. Well, one of the defenses, of course, would be it didn't have anything to do with the timing of the diagnosis, but instead the cancer itself. In Missouri, there's a business judgment rule where in the employment setting, employers can show that in the exercise of sound business judgment, that conduct or that action was taken, and that can be used as a defense to an employment discrimination claim. As I said, the third prong we look at in evaluating cases are first, economic damages. Oftentimes, that's the one the plaintiffs want to focus on. Some of the elements of economic damages would include lost wages, past and future, medical bills, past and future. And then we also have to take into account the impact of health insurance. There's the collateral source rule, which basically states for both Missouri and Illinois cases that health insurance and the evidence of a plaintiff's health insurance is inadmissible. So the fact that a health insurer may have covered and paid for some of the medical bills is not likely to be admissible and won't be used to offset some of the medical bill testimony or damages that the plaintiffs try to claim. Now, we do use evidence of health insurance as part of our settlement negotiations. Other aspects of damages, of course, include non-economic damages, pain and suffering, disfigurement, loss of consortium and comfort. And we look at the jury instructions under each of these elements of damages. The jury at trial are specifically instructed on what damages are recoverable. Other aspects of damages, as Larry mentioned, one of the significant factors can be the venue the case is pending in and the judge where the case is assigned. Very important factors. Also including under damages would be extenuating circumstances or aggravating circumstances in a death case. These are the punitive damages that we're seeing more and more plaintiffs try to make a claim to recover punitive damages. They look for and try to develop what I call heat in the case, some type of evidence that's going to get the jury angry or get the jury fired up or wanting to, quote unquote, send a message to the defendant that this type of behavior and conduct will not be tolerated. We're seeing this more and more often where plaintiffs' lawyers are trying to develop this type of argument. I make a note here about the "Are you stupid, stupid, stupid" denial letter. I'm a bit of a fan of John Grisham. He wrote a book called The Rainmaker several years ago. It was made into a movie starring Matt Damon, and it was an insurance claim in which the insurance company denied treatment to a patient, to a client rather. And supposedly in the book, the claim representative for the insurance company wrote a denial letter to the patient stating, "Are you stupid, stupid, stupid?" Well, fortunately, I've never seen that type of letter in real life. I hope I never do. But again, that would be the type of conduct behavior that the plaintiffs are really trying to capitalize on to develop evidence of punitive damages. Other aspects that go into damages in a case is the potential for recovery of attorney's fees. We see this often in our employment cases where Missouri law generally does allow for the plaintiffs to recover their attorney's fees. And we often see the fee being submitted for to be rather substantial. And in some cases, it may far exceed the amount of recovery even to the employee. We also look for contribution among co-defendants in evaluating damages, as well as potential for comparative fault on behalf of the plaintiff. Ultimately, in order to come up with and arrive at a case evaluation or a settlement evaluation, we look at the likelihood of a defense verdict, the total verdict exposure if the plaintiff is to prevail, the possibility of comparative fault and contribution. So we look at what would be the net result to our client, the defendant. These are factors. We also look at, of course, our past experience with similar cases, as well as can conduct research into settlements and verdict results of similar cases from other jurisdictions around the area. All of these factors go into evaluating a case's liability and exposure. And one of the things we do, and our clients, many clients have guidelines requiring this, but it's a good practice, is providing an early evaluation. That can be done once we have the personnel file or the medical records or the police report or that evidence I mentioned earlier. We're in a position to conduct an early evaluation of the case. And the reason is the facts rarely change. The medical records don't change. The police report doesn't change. Personnel files don't change. So we're in a position to conduct an early evaluation. Now, what that helps us do is helps us make recommendations to our client so that our client can make an informed decision on whether or not they want to settle a case. As most all of you, I'm sure, know, the majority of the cases do not end up going to trial. Many do settle. Some of the factors that go into that would include simply a business decision. You certainly want to avoid getting a target or a bullseye or a reputation of being a company that settles. If we do enter into a settlement agreement, that will certainly include a confidentiality agreement, and we certainly enforce those to the fullest extent possible. However, as we all know, once a secret is known by more than two people, it's really not a secret anymore. We also look at financial decisions as well as court-ordered mediation in determining whether a case should be settled or not. Now, finally, as Larry mentioned, certainly the impact of COVID will play into this. The courts are backlogged. Right now, cases are not really getting tried in this region, and we know there are not going to be any civil trials really for the remainder of this year in this region. And from what I'm hearing, early 2021 is up in the air. So there's a lot of uncertainty with the backlogs of the courts. We also expect that when cases do start getting tried again, criminal cases will take priority. Presumably, some of the cases that have been continued over the last 6 or 8 months will jump in there as well into trial settings. So we just know there's going to be a lot of uncertainty. Cases are going to get pushed back. And can we use that as an opportunity to maybe reach some settlements of cases that you'd like to eliminate and get off of your books? And plaintiffs, we have seen situations where plaintiffs are motivated because of this uncertainty to get that money today. And we have had some success in getting cases settled for amounts that I don't think we would have gotten them settled for 6 or 12 months earlier. That's our presentation today. One, I wanted to thank, first off, Alaris Litigation Services again for hosting us and setting up the Zoom presentation for us. Number two, of course, I want to thank everyone for attending today, particularly under these very unique circumstances. If anyone has any questions, I would encourage you to follow up with any of the presenters that you heard from today. They're happy to talk to you. I would also direct you to our firm website, where there's a great deal of information. I would ask, as Ron mentioned at the very beginning of the presentation, if everyone would fill out their evaluations and the feedback, that would be greatly helpful to us. Also, if there are any topics that people would appreciate having presented on at future seminars, we would welcome that information as well, so we can provide relevant and helpful information at future programs. Again, thank you all for attending. Hopefully our next presentation and seminar that we put on, we will be back to meeting in person. Thank you all.